CEO. This is a democratic country and it should be run with that in mind.
Catherine Delahunty.
Chair, tēnā koutou te whare. I'm delighted to take a call on the committee stages of the Crown Minerals Amendment Bill, which was a bad bill to start with and has only got worse in quite an astonishing way, really. It was bad enough at the Select Committee, going through clause after clause of facilitating mining, and Part 1 is extremely focused on assisting the mining industry and promoting the role of the Minister, not as a regulator, but as a facilitator and great attractor of industry. But then to have this SOP 205 sprung upon us on Easter Day, that was another extraordinary experience which has made this bill bad enough now a whole lot worse. And others of my colleagues will speak more about this SOP, but my own experience of what can happen, I probably would say, looking around the House, that I am probably the most experienced protester in this House. I've had more experience of non-violent protest than many of you have had hot dinners. And I have experienced what can happen on the high seas. I have had experience of what non-violence means and how the law can be misinterpreted to privilege certain industries. And when we were out in the Cook Strait once in Greenpeace protesting against a whaling supply vessel, it was really interesting because our own people were thrown off that vessel by the port police from Wellington, who were assisting the Japanese whaler to throw people into the Cook Strait 40 kilometres off the coast. And I remember thinking at the time, this isn't very safe, but of course health and safety was not the concern of the health of the Japanese whaler nor the New Zealand police in that situation. Fortunately, our people were picked up by some very skilled and fadeable captains who saved their lives. But when I read this SOP, I thought, great, it's all about those who dare to challenge, but it's not about the behaviour of people who believe that their right to extract a resource is under challenge. So it's a very concerning SOP, and it's basically, when you've been in the front line of this, you know that it isn't necessarily like the lawyers think it's going to be, and it's not just words on the page. It's about what happens to human beings who non-violently challenge the right of others to rip off resources, and it can be extremely, extremely dangerous if the rules are not fair to everybody. And this SOP demonstrates that it's actually dangerous. And I was astonished by the Minister in the House saying, no, I don't need to consult the Attorney General, no, I don't need to think about international law, no, I don't even need to answer this question, because I think that will come back to bite him in the future, that people in this country, including the New Zealand of the Year, are watching, and those people are there because they are concerned about what we pass on to mokopuna, what we pass on to future generations, and they don't regard this as something to be treated with lightness or contempt in any way. But I want to talk about Part 1 in terms of another SOP, which is my SOP 2011. And I want to talk about this one because this is another aspect of a bad aspect of this bill, which is the ambiguities around the use of Schedule 4, and this needs to be clarified for once and for all, and this bill is a positive opportunity, I believe, to do that. And so in my supplementary order paper, in Clause 16, new Section 25, what I'm suggesting is that the Minister must not grant a permit of any kind in respect of a Crown-owned mineral or petroleum in any Crown-owned land described in Schedule 4. And then it goes on to describe the land and water. But the purpose of this is to make it crystal clear to anybody that Schedule 4 is not open to mining. And it is not open to exploration and prospecting either, because exploration and prospecting are being carried out for mining, and we know that, because if you go to the Coromandel right now and you go to the Coromandel Harbour, you will find a mining company who have made public statements about their intention to mine that exact piece of harbour for tailings. That exact piece of harbour. They're not looking to get a grid picture or an aerial magnetic survey. They're there to mine that exact spot. And so we need to clarify for them, and also for the Broken Hills Mining Company over at Tairua, who have a mining permit application in front of the Minister at the moment, that this area, Schedule 4, set aside by governments, by peoples, and we had 30,000 people march on this issue, is to protect it. And so what my SOP does is clarify that there is no point in playing games. It's time for clarity. Let's say Schedule 4 is okay if you want to faucet for gold with your kids for fun, but it's not for anything else. It's not for prospecting and exploration in order to facilitate your access for mining. Otherwise, the government's playing games with the miners are confused. Mr. Chair. So I'm hoping that the House will see the clarity and the logic of what I'm proposing here, because it would be very straightforward if we could then say to everybody concerned, you can have certainty, there will be no mining on Schedule 4, so don't bother to waste your resources looking for it in those exact spots where you want to mine, because you're not going to be allowed to. That kind of clarity would be welcomed by the public of this country. And that's why I've put up this SOP, because it's an opportunity to clarify this for once and for all. Now, the whole issue in this bill is unfortunately not towards creating certainty. It's for the public, it's for creating certainty for the industry. And that's why the SOP that Minister Bridges put up at Easter was written as well, was to make sure that the industry probably didn't have to complain. I wouldn't be at all surprised if they didn't. Why would they need to? You know, a government that will let Warner Brothers write legislation doesn't really need much incentive to write legislation to facilitate people like Petrobras. They didn't have to even hear from Petrobras. They may have, but they didn't have to, because actually they were very, very upset. And the plain truth of what happened in Te Whānau Apanui is that Elvis Teddy and Te Whānau Apanui with Greenpeace went out there and said, no, we do not accept in our waters, and we don't care what you call them, but these are our waters, this is our rohe. You can call it what you like. They can call it what they like, but we're not having deep sea oil. We're not having it off the East Coast. And you know what? They won in the court, and that, of course, is completely unacceptable. Imagine a rural iwi and Greenpeace actually beating a Brazilian mining company, which the government had facilitated to come into their waters. It wasn't acceptable, and that's why we've got this SOP, because we can't have that kind of thing going on in this country. We can't have legitimate protest by tangata whenua about their rights within their own fishing waters to say no to an industry that has the risk of polluting their fishing waters. And that's what it's about. And that's why Dame Anne Salmon from the East Coast is standing with those people, because that's where she comes from and that's what she stands for. And you'll find that she's standing up more and more on environmental issues since she moved on from the Historic Places Trust, because some people at some time in their life will take a stand and say, no, it's not all right. And she has got to that point where now it's not about getting successful, it's not about being approved of by everybody, strangely, New Zealander of the Year, but actually standing up for something worthwhile, which is our environment, because without it, we are nothing. We are nothing. And that's what's so repellent about an SOP that tries to take away from Elvis Teddy, Te Whānau Apanui and Greenpeace the right to stand up. Interference can be interpreted in a million ways, and it will be. Sometimes just standing there and breathing can be considered to be, or in the water, breathing in the right zone is interference. I have been told we are interfering if we bear witness, if we stand in the way, if we put our bodies on the line. And some of the most important justice changes in the history of the world have come from people non-violently taking a stand. We stand proud in the tradition of non-violence, of taking a direct stand and putting our bodies between things that are acceptable and things that are not. And we will continue to do that despite this SOP. But this SOP has been misjudged, and it has misjudged by people who don't understand what it is to bear witness in that situation. And it has not been designed to protect everybody's rights, and that's why there's all these people making a fuss. However, there are lots of other aspects of this bill, and I am proud to stimulate emotion across the House, because it is actually an emotional issue for the people who are not the lawyers, who are not the clever people who sit around in Parliament deciding what will be legal and what won't be, but who care about this country and whose true commitment to the environment is going to be what gets us through what is actually quite a dark time in terms of the environment. So back to the bill, back to Part 1. So Part 1 has a purpose which many people came to Select Committee objected to. They objected to the purpose of the bill. And what they objected to was that most people think the minister's role is to be a regulator, is to be a fair, unbiased regulator on behalf of the community, to represent the community, to represent a fair balance of issues. Instead of which, what we find in the purpose of this bill is it's there for the efficient allocation of resources, supposedly for New Zealand's benefit, and also to be the great attractor of permits. And I think people, Mr. Chair.
Honourable Simon Bridges.
Mr. Chair, I'm proud this bill